Good afternoon, Your Honor.
Let me make sure that Mr. Hartwell gets logged in here before we get going.
Okay. Wait on Mr. Hartwell.
Gotcha.
He's there.
I talked to him.
Oh, he was there.
We have some time. All right, Mr. Stevens, is this your writ on Charity Robertson for writ seeking bail reduction?
That is correct, Your Honor.
All right, are you going to call Ms. Robertson to testify today?
Yes, sir.
All right, Ms. Robertson, if you will, raise your right hand so I can place you in oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure during your testimony that you speak up loudly and clearly so I can hear you. Just make sure that you allow Mr. Stevens to finish his questions before you give any answers. Okay, go ahead, Mr. Stevens.
Thank you, Your Honor. Please state your name.
Charity Robertson,
Ms. Robertson, how long have you been in jail?
48 days.
Okay, and you're being held on 2 bonds, each of $50,000, and you've not been publicized, is that correct?
Correct.
You don't have any money, do you? Financial institutions.
I do not know.
Do you own any property? You sell upon or mortgage to help put toward the bond. And there's a couple of issues going on right now we will let the judge know about. Number one, you have some medical problems, correct?
Yes.
And just tell the judge what it is instead of me just asking you.
Okay, so in December, I went to the doctor and they told me that I had an HPV high risk and I needed to get that removed. And so it does not turn into cancer pretty quickly. And I had a doctor's appointment. It's kind of hard to get a doctor's appointment, but I had one in May, back in May, at the beginning of May, that I've now missed.
Do you believe that might be jeopardizing your health?
Yes.
You have another issue too. The gentleman that you're living with in Roy City, you've been told is hospitalized with COVID and with cancer. Is that
No,
correct?
tuberculosis.
Tuberculosis.
Yeah,
You're afraid he might not make it out of the hospital.
that's what they're saying. Yes.
And all of your property is actually at his location.
Yes.
And you'd like to get the bonds reduced or even ask the judge for a PR bond to take care of that.
That's correct.
Get your property out of there and then also to take care of your medical condition, right?
Yes, sir.
Do you have transportation?
I don't need to get to court yet, so I don't have transportation myself, but I have definitely support that will get me where I need to go right now. But I'm working on transportation.
I don't think your mom even wrote a letter. I don't know if the judge has seen it, wrote a letter to the court and came to me, the court, this attorney explaining that she would make sure you got to and from the courthouse.
Yes, she did.
Okay. And you do not have any. You don't have any other like that.
Mr. Stevens, I'm having a hard time hearing you because when you turn and you look at her, the microphone's not picking you up. So y'all might need to move up a little closer or
Yes,
face the microphone when y'all talk. Otherwise I can't. It sounds very garbled.
Sorry about that, Judge.
But
What I was asking is, she doesn't have any holds anywhere. Is that correct?
That's correct.
Okay. And are you asking the judge to grant a PR in this particular case?
Yes.
In both of these cases? If the judge is not inclined to grant a PR bond, you have some limited resources through your friends. Is that correct?
Friends and family, yes, sir.
And you could probably come up with about a $2,500 bond on each of the cases that you're asking for a personal bond.
Correct.
If the judge either produces a bond store you can get out or grants you a PR bond, you understand there'll be obligation that'll be put on you to come back and forth to see the probation department for pretrial release. You're able to do that, or you not?
Yes, definitely.
Okay. Pass the witness, Your Honor.
Mr. Hartwell, any questions of Ms. Robertson on the issue of bail?
Your Honor, I don't think I do on this one. Thank you.
Mr. Stevens, can you tell me what it is she's charged with? I don't see it in your writ, and I don't think I heard her say it.
It's 2 charges of theft, Your Honor.
What level of theft?
Let's see. Burglary of a building, Your Honor, and a theft. They're both state jail levels.
Burglary of a building
Yes, sir.
and state jail theft.
And
Yes, sir.
Your Honor, sorry to butt in here. To the best of my knowledge, these are 2021 warrants. State does not have PC affidavits on them yet.
How long has Ms. Robertson been in jail?
48 days, Your Honor.
48 days?
Yes, sir.
So you said, Mr. Hartwell, that the DA's office has received no PC affidavits, no kind of cases, and the warrants are back from 2021.
Correct, Your Honor. To the best of my knowledge, this is the 2021 warrant, and we do not have PC or ACEs on them yet.
Anything further, Mr. Stevens?
No, Your Honor.
And does Ms. Robertson have any criminal history?
Not that I'm aware of, Your Honor. One thing I didn't mention, her son graduated from high school here recently, which she was not able to attend that.
All right, anything further, Mr. Hartwell?
No, Your Honor. Thank you.
All right, court will take this under consideration, and I'll issue a written ruling at the end of the docket today.
Thank you, Your Honor. That's all my business. I'll be excused.
Yes, sir, thank you.
Thank you, Judge.
Mr. Command, who do you have with you?
Jason Trout.
Right, and are we doing that plea agreement today?
We are, Judge. Do you have the terms and conditions before you need me to recite those?
I need you to recite those. I don't have anything.
We're pleading to a lesser included state jail possession, penalty group 1 less than a gram under 1244A, Texas Penal Code. 270 days in the county jail. She's got credit for 270 days. 180 restitution to DPS laboratory. $290 in court costs. There's $85 in reimbursement. In addition, the DA's office is taking into consideration under section 1245, 3 offenses, DA 2022, 437, 438, and 435.
Mr. Schmidt, should the reimbursement be higher than that? Are you retained?
I'm not retained, Judge. I would suspect that it should be higher than that. I saw it on the judgment and I thought there was a reason for that. So obviously I didn't question that, but the standard would be 500.
All right, Mr. Hartwell, can you talk with your staff? I believe that the reimbursement should account for reimbursement of the indigent attorney fees that Mr. Schmidt is being provided for his service. And I think the flat fee we're doing at this time is 500. So I'm thinking
Well,
580. Is that correct, Mr. Schmidt?
it would be 585 total, I guess. I don't know what the breakout is for the 85. But ultimately, the judgment that I received, I reformed that in my office myself because of the way it was written. It was incorrect. So I corrected the judgment and with communication with Ms. Curry. So it reflects what she and I talked about. But so in other words, if I need to add 500 to the judgment, I can run to my office and just fix that and print it. Because the state's original judgment is not the one I have in my hand. It'd be faster for me to do it, in other words, is what I'm saying.
Sure. Well, let's do that. Since the plea is changing to a 1244A, then I think Ms. Trout should be ordered to reimburse Van Zandt County what it's paying on her behalf for her representation.
We understand.
Okay, so I'm gonna go ahead. I'll recall you later, Ms. Trout, and we'll give Mr. Schmidt time to get that corrected judgment. That way we can do it all at one time and be done. Mr. Noel, you ready?
We are ready.
He's just gonna reset.
Okay.
All right, this is CR 21-51, State versus Brittany Chumley. Arraignment on 3rd-degree prohibited substance for item and correction facility. Are you ready for arraignment, Mr. Noel?
No, we are good. Assembly has reviewed a copy of the indictment. His name is spelled correctly, and for the purposes of arraignment, we'd enter a plea of not guilty. Judge, the only other thing I didn't, for whatever reason, the lab report was not on the web portal, so I got a copy of that this morning. I had a little bit of time as the court may have noticed with Mr. Hartwell this morning, it's a 900th of a gram. Happened to be in a shirt pocket when he was arrested on another misdemeanor. There was a PR bond that was done back in the midst of COVID. It was more than a year later before the lab report actually came back. Shortly after that, there was an indictment. He has missed a court appearance. At this point in time, my understanding, his father is in ICU at Texoma Medical Center in Sherman. I think it's stage 4. I would be asking the court if we could get a PR bond. We would reset it. If we got the PR bond for June 29th, I think we can have a plea worked out by then. He understands that if he fails to appear, there would be even a more serious charge filed, that the court would consider that.
Have you talked to the state about that as to whether they're in agreement? Because to my knowledge, there's no motion filed for a PR bond, so.
There is no.
So the court, of course, unfortunately not going to take that up without it being noticed to the state. So unless the state's in agreement, I believe that you would need to file that, and we would need to set up for a hearing so that the state would have notice.
Judge, we talked about, I think I talked to Mr. Hartley briefly, but he was in the middle of two other cases this morning. Mainly, I talked about the case, which he completely candid, and obviously, apparently, he's worked at 2 courts, felonies and misdemeanors, and he didn't have much information on this case at that time. And I didn't have a motion to file because I didn't find out about the situation until sometime on Tuesday. I think it was Tuesday.
Right. So let's do this. I'm going to find that Mr. Chumley has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. Let's go ahead and set it for a pretrial. And then if you and Mr. Hartley or you and Ms. Curry can come to an agreement on whether or not there's an agreement on a PR bond, then y'all can send that agreement over. If not, then file your motion and I'll get it set for hearing.
That just go ahead and also keep it set on the for plea. I think he may have his 21 months credit. Part of the time he was in on a Hunt County case. One time there was a hold there, county charge, and then he got released from the state jail. Well, for some reason, he'd been in this jail 4 months before he got the PR bond. He's been back now about a month. So I think he actually had 4 months credit.
Yeah, I couldn't hear that last word. Yes. How many months credit?
I believe it's going to be 21 months credit.
Okay. All right. Well, I'm going to let you and the state work that out.
Okay, and can we go ahead and keep it for the 29th, and I guess at 1:30?
29th is going to be an evidentiary day. I can set you for the 27th.
Okay.
Well, I mean, if you need a hearing on the motion to reduce bail, I can set you on the 29th for evidence on that. Would you rather have the 29th or the 27th?
I think I'd rather have the 27th, sooner the better. I'll get with I guess by email or phone and see if we can agree to some sort of bond.
All right, cool. Court will set Mr. Chumley then for motion to reduce bail on June 27th. We'll set this matter for pretrial hearing. Are you available on July 11th or 13th if y'all don't get it worked out?
I'm sorry, Judge, of course, I left at 13th.
Yeah, July 11th or 13th for pretrial in case y'all don't get it worked out by the 27th.
Okay, let's make it July 13th.
Okay, we'll go ahead and set this matter for pretrial July 13th at 1:30.
But as of now, we have it set for June 27th, correct?
On motion to reduce bail. So you'll need to file that and give the state notice. And then if y'all work it out before then you'll send it over. If not, then we'll hear it on the 27th.
Thank you, Judge.
You're welcome.
Hey, Your Honor, Mr. Versace is ready for his plea on Everton Steward.
All right, court calls cause number CR 11-45, State versus Everton David Steward. Mr. Steward, Sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. Speak up loudly and clearly for me today. Mr. Steward, you appeared before the court previously back here on February 7th of 2012. You were convicted of the offense of possession of marijuana, 4 ounces to 5 pounds. The court heard the evidence and followed a plea agreement on that date. The court assessed your punishment at 18 months confinement in the state jail division of TDC, ordered you to pay a $2,000 fine. The court then, pursuant to your plea agreement, suspended that sentence and placed you on community supervision for a period of 5 years. It was during that period of community supervision that the state filed its motion to revoke your community supervision, and they alleged to the court that you have violated in 12 separate counts. Have you had sufficient time to talk with your attorney, Mr. Versace, about that motion to revoke?
Yes, sir.
Do you understand everything that you've read and signed today in your plea agreement?
Yes, sir.
All right, and Mr. Are you pleased with Mr. Versace, his representation of you and the work he's done?
Yes, sir.
Mr. Versace, do you believe that Mr. Steward is competent to enter into this plea agreement?
He is, Your Honor.
All right. All right, and so does your client intend to waive the formal reading of the state's motion to revoke, and is he intending also to plead true to all counts?
We do, and he would plead true to all counts, Your Honor.
Okay. All right, then, Mr. Steward, I would ask you at this time, how do you plead to counts 1 through 12 as contained in the state's motion? Are those counts true or not true?
True.
And are you telling me that each one of those counts are true because in fact, what is alleged is true? You're not just saying that to get a plea agreement, correct?
No, sir. I'm 100% positive it's true.
Okay. And has anyone threatened you, forced you, pressured you to plead true to any count today?
No, sir.
All right, court will accept the defendant's plea of true to each count. Mr. Versace, any objections to the admission of the defendant's waiver of rights of plea of true?
No, Your Honor.
All right, court will take judicial notice of Mr. Stewart's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
I want to let the court know that $2,800 today that should zero out on this case.
And sorry, repeat that last part. We're having some bad technical difficulties today. I can't. Every other word is kind of good. Now you said he paid $2,800.
$2,818, which zeroed out everything at this point today.
Okay, great. Thank you. All right, then, based on the evidence and the judicial confession of Mr. Stewart, the court will find that Mr. Stewart has violated the terms and conditions of his community supervision. The court will follow the plea agreement in this matter. The court hereby revokes the defendant's community supervision, assesses his punishment at 6 months confinement in the state jail division of TDC, orders him to pay the balance of his financial obligations, which apparently he has already done so. Court awards Mr. Stewart 107 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Stewart, you hereby remain into the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over with the deputy to be fingerprinted. Thank you, sir.
Thank you, Judge.
You're welcome. Thank you, Mr. Versace. All right, you're back, Mr. Schmidt, on Ms. Trout.
Yes, yes, sir.
Okay, we ready to go?
You're ready to go?
You were fast about that.
Yes, sir.
We'll have to pull that camera footage, see if you sprint it over or what you did.
I don't spread. Fat nose and strong.
Is Miss Abraham in there?
Yes.
Yes, Your Honor.
Miss Abraham, I don't know if there's something going on with a microphone or what, but we're just having a very hard time. Everything's kind of muffled. It doesn't seem to matter how close you get or how far back. Sometimes it's just cutting out. I don't know if the settings have been changed or we need to unplug it, plug it back. I don't know. Something's going on.
Okay.
Mr. Hartwell, is it coming in clear to you or is it sound muffled?
Their microphone's coming in a little bit muffled and a little bit broken up too. I'm having to turn up my speakers to hear it.
You both are very clear here.
Yeah, y'all are real clear for us.
As clear as you get.
Is that any better?
So far,
It is lagging, Judge, like it was the other day where you're speaking, but then it, your mouth keeps moving and no more sound.
yeah, it must be the connection.
Yes, sir.
Y'all
Start my
speak
video,
up.
start my video, start my-
Y'all speak up.
Okay.
We'll try it again. All right, we're back on the record. Miss Trout. Miss Trout, if you'll raise your right hand, I'm going to place you under oath. I don't know if I did that a moment ago. We're going to do it again. Miss Trout, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help me God?
I do, Your Honor.
Thank you. All right, so let me repeat what you told me earlier, Mr. Schmidt, so I can be clear. Ms. Trout is going to plead guilty to a lesser included state jail felony offense, possession of controlled substance, penalty group 1, less than 1 gram, prosecuted under section 1244A, 270 days in jail, credit for 270 days, $180 restitution, $290 court cost, $585 reimbursement fees, and 1245-2022-435-437-438.
That's correct, Judge.
Okay. All right. Ms. Trout, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Yes, sir, I am.
You feel like you've had enough time to talk with him about your case, and that you've had all of your legal questions answered?
Yes, sir.
You're pleased with the work that he's done for you on this case, is that correct?
I am, Your Honor, yes.
Mr. Schmidt, do you believe your client to be competent and that she's entering into this plea intentionally knowing it's voluntary?
Yes.
All right, Ms. Trout, you've heard Mr. Schmidt and the court talk about what the plea agreement is today. Is that your understanding of the plea agreement?
Yes, sir.
All right. Then the court finds that under section 1244A, the proposed plea agreement does fit within the lawful range of punishment for a state jail felony prosecuted under section 1244A, with a maximum being 365 days in the county jail. So Ms. Trout, at this time, how do you plead to possession of a controlled substance in penalty group 1, less than 1 gram, a state jail felony prosecuted under section 1244A?
Guilty?
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
I am, Your Honor, yes.
All right, court will accept the defendant plea of guilt at this time. Mr. Schmidt, any objection to states 1?
No objection.
States 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
Nothing further.
All right, Mr. Hartwell, can you summarize the evidence to support the plea for the court? I don't have any of that here.
Yes, Your Honor. I'm just looking up the date now. Looks like April 7th of 2022. Chief Long pulled over Miss Trout for expired registration and failing to keep right at the Rose Monument in Wills Point. Upon contact with Miss Trout, Chief Long noticed that she had constricted pupils, appeared nervous, shaking hands. Chief Long asked her if she had taken anything. She denied taking any substances. He asked her if there was any narcotics in the car. Miss Trout gave consent to search. Upon searching the car, Chief Long found some paraphernalia, asked about it, and Miss Trout did admitted to Chief Long that there was some heroin in the car, and Chief Long did find a quantity of heroin exactly where Miss Trout told him it would be.
All right, thank you, Mr. Hartwell. And what was the results of the lab and the amount?
1.95 grams of heroin.
Yes, Your Honor.
Thank you. All right, any objection to that summary, Mr. Schmidt?
No objection, so.
All right, then based on the evidence presented, the court finds that there is enough evidence to convict Ms. Trout of this offense. Court will follow the plea agreement. Court hereby convicts Lisa Renee Trout of possession of a controlled substance, penalty group 1, less than 1 gram, a state jail felony, assesses punishment pursuant to section 1244A of the Texas Penal Code at 270 days confinement in the Van Zandt County Jail, awards Ms. Trout 270 days credit towards that sentence for time previously served. Court orders her to pay court costs of $290, restitution of $180, reimbursement fees of $585, and the court dismisses under section 1245, cause numbers 2022-435-437-438. Ms. Trout, when you are released from custody, you need to come over to the courthouse and make arrangements to pay off the monies that you owe. If you can't pay it all off at one time, then you can meet with the court compliance officer to set up a payment plan. Your failure to pay off your fines, court costs, or to comply with your plan will result in the court issuing a warrant of arrest. Do you understand that?
Yes, sir, I do.
All right, please step over with the deputy. I'm going to remand you to the custody of the sheriff's office. He's going to take your fingerprint. All right, Mr. Manning, who are you ready on?
Judge here, ready on Ms. O'Pry continuation from this morning.
All right, go ahead.
Judge, I'd like to call my client to testify.
All right, Ms. Albright, if you'll raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, go ahead, Mr. Manning.
Ms. O'Pry, you have some medical history that you've been dealing with during the pendency of this case, is that correct?
Yes.
Okay, and what are the specific issues or illnesses that you've been dealing with while this case has been before this court?
Cyst on all female organs, cyst, a different kind of cyst in my lymph nodes. I have scar here where these lymph nodes have been removed. And anytime that these cysts keep rupturing at any given time, it causes an infection all over my body to where we put drain tubes in and catheters in, trying to keep it from turning to sepsis. And I've been really ill over that, just from the infections also.
Okay, and during the course of this case, have you had hospitalizations?
Yes.
Okay, and have you had surgeries during the course of this case?
Yes, well, the minor surgery for the drain tube and catheter.
Okay, and you were on medication as recently as last week for different symptoms or illnesses associated with your medical condition. Is that correct?
Yes.
And you were unable to provide a specific list, but approximately how many medications would you say you're on?
It varies. I mean, whatever's needed at the time. I can get the list. If I can get back to my computer, I can give you copies of whatever you need.
But for the purposes of this hearing and for the court record, would you say that you've been on more or less than 10 medications?
Less.
Okay, more or less than 5 medications?
Around about that, or maybe just slightly less.
Okay, and were those medications generally for inflammation and infection? What type of medications were those focused on?
For inflammation, and then like a steroid trying to strengthen, and then something trying to dissolve any of the cysts before they do surgery.
Okay. And you're unaware of the specific medications you're currently taking without having access to your medical records.
Correct.
Okay. And which doctor are you under the care of? Which physician?
I don't know. I guess my primary care physician.
Okay.
I mean,
And what's their name?
Dr. Craig.
Okay. And where's Dr. Mullins?
I couldn't hear what she said on the name of the doctor.
Dr. Craig McMullins, sorry.
Greg McMullins, okay.
Neola.
And his office is located in Mineola? Okay. And are you also under the care of a surgical team and a oncologist?
Yes, in, spring.
Okay, and which, while I know you don't know the name specifically, which group are they under? Which health group are they under? UT?
Yeah, I mean, I could.
I'm sorry, Mr. Manning, we're not hearing what she's saying. We didn't hear the last thing she said to you. We didn't hear that at all.
I asked her what system, medical system that she was going, where her doctors were located, and her answer was she thinks it's UT. She goes to UT. She thinks it's UT.
Okay.
Have you tested positive to or admitted to using any drugs during the course of your pretrial supervision while on bond for these cases?
No, other than today.
Okay. And have you been tested for drugs, illegal substances, alcohol while you've been on pretrial release?
No.
Okay.
Thank
you. And are you concerned for your safety and health if you have one of these cysts burst while you are in the Van Zandt County Jail?
Yes, very much so.
Okay. And are you able to assist in providing the court more information about your medications while you're in jail, away from your computer and other medical records? Are you able to assist me in providing the information about your medications while you're here in jail?
No.
Okay. Is there anybody on the outside that could assist me in providing those medical records to the jail? Okay. Have you been able to stay in a consistent housing situation while you've been on bond in this case?
Yeah.
And where have you been staying while you've been on bond?
Lots of different ways.
You need to speak up so they can.
My main one in Dallas with my ex-husband, due to all the other things that have come along with this case, my son is in a stable environment.
And to your knowledge, are any locations that you've been staying at, do any of those individuals use illegal substances?
Yes, I found that out. And that he was using that and also giving it to his mother.
And you're not saying that this is your ex-husband, this is some other person, is that
Right.
correct?
Correct.
And did you report that to someone?
Yes, I did.
Okay. But you have not ever used or taken any illegal substances while you've been on bond, is that correct?
Correct.
Judge, may I have just a moment of my time?
Okay.
Your Honor, at this time, I pass the witness.
Mr. Harwell, any questions of Ms. Albright?
None at this time, Your Honor.
And Judge, if I may just make a brief argument.
Go ahead, sir.
Judge, Ms. Pry, while having a tendency to be late sometimes, has always appeared, despite whatever medical conditions that she has, for court, she has been in compliance with the exception of some late payments or some delinquencies on her conditions of pretrial release. She does have, as the testimony has shown today, she has serious medical conditions that if left untreated or if left to be without care, constant care of her medical doctor, could lead in much more serious issues like sepsis. We will request that she be placed back on bond and in an effort to continue supervision, maybe have her pretrial appointments move to a little bit more regularity so that the court can continue watching the situation, but allow her to get the treatment that she needs in order to stay healthy and alive.
And Mr. Manning, when did she say her next doctor's appointment is?
Judge, I did not get testimony on that. If you like, I can reopen and get testimony about the frequency of her appointments as well as when her next one is scheduled.
Why don't you just ask her? She can tell you and you can tell me.
Your Honor, her last appointment, she believes, was in May. And at that point, what they're doing is they're prepping for surgery. As she said earlier, the medication, one of the medications she's taking is an effort to shrink down the cyst to be able to have surgery. And so at this point, they were waiting for that medication to take effect. And so she did not have the pre-op scheduled at this point in time. But her last appointment was in May to check on the status of those cysts.
She doesn't know what kind of medication she's on that could be resulting in a positive meth test.
Judge, I asked her some of the common contraindicators preparation for this hearing, but she was unable to give me specifics as to the medication that she was on and what specifically those were treating for. We were only able to discuss generally what medication she's been on as part of this regimen of treatment.
Okay. All right, the court will take the request under advisement and we'll make a ruling at the conclusion of the docket.
Yes, Judge.
All right, this is cause number CR 22-390, State versus J. Warren Penny. And Mr. Pat, I'm sure that we're set for docket call today. Are you ready for docket call announcement?
I am, Your Honor.
All right, go ahead.
Your Honor, the court recalls there was a pending motion for suppression that, of course, I was in another county and I thought we were past it, but however, the court had called it and denied my motion due to not being able to go forward. And I renewed my motion, so I was going to kindly ask the court if we could set it again for pretrial. And just for the court's information, there's this indictment, there's other charges that are pending in Wood County, and I'm negotiating with Wood County District Attorney and hoping there could be a global resolution that includes this matter here. But to keep this thing moving, I'm going to kindly ask the court if we could set this again on pretrial.
You're asking for another hearing on your pretrial motion for motion to suppress?
Yes, Your Honor.
Any objection from the state?
Your Honor, seeing as there's still a chance that this may result in a plea. If the court were to make an exception to its ordinary rule, I would ask that this be placed on the trial docket with the understanding that the court may make an exception to its policy of accepting pleas after. If the court is not wanting to make an exception to that, I wouldn't have an objection to one more setting.
All right, the court will set the motion to suppress for hearing in 2 weeks on June 29th at 1:30.
Thank you, Your Honor.
You're welcome. All right, if there's nothing further, then we'll be adjourned in this case.
Thank you, Your Honor.
You're on.
It's the job.
None of this, if they want to take a break, I need to take work.
Your Honor, Mr. White is here, but we do not have his paperwork yet on Mr. Balboa. Mr. Manning is going over plea papers. And the only attorney that we do not have is Mr. Adams, who, we appointed yesterday. So I'm not sure if he's coming today or not.
Okay. Okay. All right, then I'll stay in recess until Mr. Manning and or Mr. White are.
Okay. We'll text you when we're ready.
Thanks. Mr. Manning, you ready? All right, Mr. Manning, are you ready?
Judge, this is Mr. Dicapa.
All right, this is cause number CR 17-283 and CR 20-113 State versus William Thomas Dicapa. And it's my understanding that Mr. Dicapa will be entering police today.
That's correct, Judge.
Can you tell me the terms of the plea agreement?
Yes, he has two cases. One, the first is CR 17-283. And that is going to be a motion to revoke and adjudicate guilt. He will be pleading true to all counts. And punishment will be assessed at 8 months state jail, balance of financial obligations. And that those financial obligations show to be $1,500 for the fine, $155 for restitution, and $454 for court costs. In addition, he has 171 days credit, and that's for CR 17-283. In cause number CR 20-00113, that is a newly indicted charge that he will be pleading guilty to. Upon a plea of guilty, the state agrees to recommend punishment be assessed at 8 months state jail, $180 restitution, and that time will run concurrent with the previous case CR 17-283. In addition, he has $209 court cost, $35 reimbursement, and the time he has for that is 75 days credit.
All right, thank you, Mr. Pull up this motion. All right, Mr. Dicapa, if you'll raise your right hand, I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Right. All right, Mr. Dicapa, you heard the plea agreements that Mr. Manning read to the court. Is that your understanding of the plea agreements today?
Yes, sir.
All right, and Mr. Dicapa, you previously appeared before the court on May 14th of 2019. Cause number CR 17-283, you pled guilty to the offense of possession of a controlled substance, a state jail felony, penalty group 1, less than 1 gram. The court heard the evidence that day, deferred a finding of guilt pursuant to a plea agreement, placed you on 4 years community supervision, ordered you to pay a $1,500 fine. It was during that period of community supervision that the state has filed its motion to adjudicate and revoke on December 10th, 2019. And in that motion, as you see here, I'm displaying it to you, court bears 10 separate counts of violations. We had enough time to talk to Mr. Manning about this motion to adjudicate and have all of your legal questions answered.
Yes, sir.
Are you pleased with Mr. Manning's representation of you on this case?
Yes, sir.
Now, in cause number CR 20-113, you are charged by indictment with a state jail felony offense of possession of a controlled substance. Penalty group 1, less than 1 gram. That does carry a range of punishment, not less than 6 months in prison or more than 2 years of prison, and an optional fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
Mr. Dicapa, has anyone threatened, forced, or pressured you to plead in either one of these cases today?
No, sir.
You understand everything that you've read and that you've signed?
Yes, sir.
Mr. Manning, do you believe Mr. Dicapa to be competent?
I do, Judge.
You've explained to him his rights as they pertain to both the motion to revoke and the newly indicted case, correct?
I have explained both of those sets of rights to him, and he understands those.
Thank you, Mr. Manning. All right, Mr. Dicapa, then, and Mr. Manning, does Mr. Dicapa waive the formal reading of the state's motion to adjudicate to deceive? You said he does intend to plead true to all counts, correct?
That's correct, Judge. He does agree to waive, and he does intend to plead true to all counts.
All right, Mr. Dicapa, as to the motion to adjudicate, how do you plead to counts 1 through 10 as contained in the motion? Are those counts true or not true?
True.
You know, you're telling me that each one of these counts is true because in fact, what the state has alleged is in fact true. You're not just saying that to get a plea agreement, correct?
Yes, sir.
All right, and as to the charge of possession of controlled substance, penalty group 1 and cause number CR 20-113, how do you plead to that offense? Guilty or not guilty?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
No one's threatened you, forced you, pressured you to plead guilty or true in either of these cases. Is that correct?
Yes, sir.
Right. The court will accept the defendant's plea of true and also his plea of guilt. Mr. Manning, any objection to states 1 and CR 2113 or any objection to the admission of the defendant's waiver of rights and plea of true, CR 17283?
No objection to states 1 in either case.
All right, the court will admit the evidence supporting the pleas. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
Nothing from the defense, Judge.
All right, and Mr. Hartwell, can you give the court the evidence to support the plea for CR 2113?
Yes, Your Honor. On October 12th, 2019, Trooper Howell was on patrol. Noticed the defendant, the truck that the defendant was in, there were two occupants of the vehicle. Noticed that the registration was not displayed. And that neither occupant was wearing a seatbelt. Trooper Howell turned around to make a stop. The vehicle pulled over. Both occupants opened their doors, attempting to step out. Trooper Howell had him get back in, and after making contact with them, was able to talk to them a little bit further, had them step out, frisk them for weapons. During that time, he observed a clear plastic container containing a green leafy substance in Mr. Dicapa's pocket. And then upon further search, found a clear plastic bag containing a clear crystal-like substance believed to be methamphetamine. Labs came back and tested that came back at 0.29 grams of methamphetamine.
Thank you, Mr. Hartwell. Mr. Manning, any objections to that summary?
No objections, Judge.
All right, then based on the evidence presented to the court today, the court finds that Mr. Dicapa has violated the terms and conditions of his community supervision and cause number CR 17283. Court, based on that finding, revokes his community supervision, imposes sentence pursuant to the plea agreement at 8 months confinement in the State Jail Division of TDC, orders him to pay the balance of all financial obligations, and awards him 171 days credit towards the sentence for the time that he has spent in jail on this cause. In CR 2113, based on the evidence, the court finds that there is sufficient evidence to convict Mr. Dicapa. Court follows the plea agreement, adjudicates his guilt today, assesses his punishment at 8 months confinement in the State Jail Division of TDC. Orders him to pay $180 restitution, $290 in court costs, $35 in reimbursement fees. The court awards him 75 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Dicapa, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy to be fingerprinted.
And Judge, before we proceed, there was two housekeeping things that Mr. Dicapa would like me to address with the court. First was he was requesting the good time credit presumptive from the court. I explained to him the court's policy but he does request a good time credit. While he's been in jail here, he's attended AA rather successfully and is also a trustee as well. And so he's requesting that. I explained to him that you would review those applications that come from state jail and that you do them on a case-by-case basis based on the affirmative things that they're doing, as well as the lack of any infractions or offenses while they're down there in state jail. Additionally, the other point and request we would have is, it looks like I was also pointed to a misdemeanor possession of marijuana. Until Mr. Hartwell gave that summary, I'd forgotten that had also been appointed. That was back when we were still doing misdemeanor appointments. And we'd ask that we put some type of disposition on the record for that misdemeanor case that doesn't clog up stuff in the future.
Yes, Your Honor, state would agree to reject that misdemeanor marijuana case as part of this agreement.
Right, leave us noted for the record. As for Mr. Dicapa and the good time credit, if any of the jail staff were to communicate to Ms. Abraham anything about Mr. Dicapa and his trustee status, behavior while it's there, I will certainly take that into consideration. And then whenever I'm notified by state jail, then I would review that in conjunction with their records too. Ready on anyone else?
Yes, Judge. Mr. Michael Davis.
Michael Edward Davis, CR 22-176. I believe that we're set for docket call, and then I believe you also filed a motion for bail reduction.
Yes, Judge. Mr. Davis was arrested on some new offenses, and the state has not timely filed an indictment or information on any of those. And so we requested that those be given PR bonds. I believe at this point he has served, I think, 98 days. And he has been arrested continuously, as my motion says, since March 4th of 2023. Those are for evading arrest with detention with a vehicle, and evading arrest, detention, a prohibited substance, manufactured delivery, and evading arrest are the cases that he's currently on unindicted on.
Any response from the state?
That's correct, Judge.
All right, so state's not in opposition of his request in the writ cases.
Yes, that's correct, Judge.
Okay. All right, and as for docket call, Mr. Manning.
Judge, at this point, we would like to reserve our announcement on docket call until we figure out what's going to be happening with his other cases. Like I said, those were recent arrests, and I'm not sure that the DA's office at this time has received reports on those. With my last check, they had not, and so I'd like to see, before we proceed the trial docket, if there's not something we can resolve all cases with. The last offer I had, my client was going to reject, but since then I've spoken to Ms. Curry, and there may be some room for negotiation once they get some reports in and we figure out where his position stands.
All right, we'll take the writs under advisement. Mr. Willing at the docket. Or we'll reset Mr. Davis for an additional docket call on August 10th.
Thank you, Judge.
Are you ready on now, Mr. Meany?
Judge, next ready on Mr. Shaw.
All right, this is Red WR 23-42. Yeah, Mr. Shaw, if you raise your right hand, please shoot the oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So,
Yes, sir.
all right, then lower your hand. Just keep on speaking out clearly for me. Go ahead, Mr. Meany.
Yes, Judge, this is also a writ for delay under 1751 for the charges of arson, evading arrest, detention, and criminal mischief. My client was arrested on March 9th of 2023 on the arson and evading arrest, and was arrested on January 31st on the criminal mischief. I'm sorry.
I caught the criminal mischief about 2 weeks after I was in here.
The criminal mischief was filed after the other charges. So he's been in at least 90 days. We request relief under 17-151.
Your response on state.
Judge, Mr. Manning is correct. He has been in that long and we have no other response.
All right, thank you, Mr. Green. All right, Mr. Manning, court will grant the relief requested, and I'll sign that order at the end of the document today.
Thank you, Judge.
Thank you. I see you. Thank you.
What are you ready on these?
Judge, next ready on Mr. Ozuna.
All right, this is cause numbers CR 22-385 and CR 22-282, state versus Richard Ozuna Jr. for pretrial code.
Yes, Judge. I received information from the CKC services that they did an evaluation and were able to locate footage that would be dispositive on our case. However, they were unable to send it to me due to the size of the files and the program that was necessary to review that. I have requested they send a download of that to me with a physical copy, and they are in the process of trying to get that done. My last conversation with them was yesterday, and they anticipated being able to do that by the end of this week. My hope is that once I have a chance to do that with my client, like I said, I believe that's going to be dispositive to this case.
I think we set it June 29th. 2 weeks.
Judge, that'd be fine.
Okay. All right, we'll set Mr. Ozuna then for status on June 29th.
And just so our record is clear, Your Honor, I don't know, I don't necessarily agree that whatever footage there might be is dispositive.
Okay. When I just set it for status on video evidence, so he gets the video evidence back, then we should be able to at that point then move it over to docket call at the very least.
Yes, sir.
All right, thank you, Mr. Ozuna. You can go.
Sir, thank you.
Who's next, Mr. Reed?
Judge, my last one is going to be Mr. Hicks. Judge, I have Mr. Hicks' case. If I may have just a moment to speak to him, I received some information from the DA's office yesterday that this was originally set for a plea, and that's going to alter the situation. And so I'd like to speak to him just a moment.
Right, and you also have Cody Lee Wellborn and Mark Walcott. Just make sure you're aware of that.
Yes, Judge, they have not been brought over at this time.
Okay, yes, go ahead.
They'll be up here in a minute. Okay, what do you want me to do about Mr. Copeland?
Do we know when Mr. Adams is going to be back?
No, sir.
Yeah, I don't either. I had that smart bench program we had years ago that I was promised I'd be able to look that up, tell you, but I don't have that ability anymore. So we're gonna have to just reset that, I guess. It's for arraignment. I know Mr. Copeland's pending trial. It's detained for that purpose, so
What information do you need, Your Honor?
the next time Mitch Adams will be here, scheduled to be here. He's scheduled to be here today for arraignment. He took Mr. Copeland's case. He's not on the court appointment list anymore. He took Mr. Copeland's case at the request of the court. So I'm trying to schedule him when he's going to be back. I just don't know when that's going to be. Tell you what, give me a second, Mr. Abraham, and I'll go see if I can figure it out.
Okay, thank you, sir.
He had a case Tuesday, Judge, that turned in that docket.
Your Honor, I know Mr. Adams has reset 713 from one of Tuesday's cases. But other than that, I'm not sure.
Okay, well, let's do that then. Let's reset Mr. Copeland in for July 13th for arraignment. All right, let's take a recess, give Mr. Meany opportunity to speak with his clients, and then Mr. White opportunity to speak with Mr. Balboa or party. Oh, I'm sorry, Mr. Green. I was on another screen working. All right, are you ready on Mr. Hicks?
Yes, Judge.
All right, this cause number CR 22-356, CR 22-399, State versus Braylon Higgs. Or Docket call. Go ahead, Mr.
Judge, we actually had reached a plea agreement in this case, and that plea agreement was something that was agreed to after our last court setting. I was called by the DA's office yesterday and was told that that offer was withdrawn and that there was currently not an offer for Mr. Hicks's case. And at this point, my client has requested that we announce ready for trial.
Thank you, Mr. Green. All right, court will set Mr. Hicks for trial. We're just going to specially set Mr. Hicks for trial March 18th.
And Judge, in the interim, I'm going to be filing several motions in requests for expert testimony, as well as mental mitigation, and those will be forthcoming. But I would appreciate us go ahead and get a special setting on that case.
Okay. I'll be looking for those. So yeah, we're specially set March 18th. Any time for Mr. Wellborn, Mr. Walcott.
Judge, I also have Mr. Henson, who was set on a writ.
Okay.
If we could go ahead and handle his writ.
All right, Joseph Henson. Writ WR 23-43. Go ahead, Mr. Reed.
Judge, this is, as with the previous three, this is a 90-day writ. Give me just a moment. Under 17-151, my client has been charged with assault, driving while licensed invalid, display of fictitious motor vehicle registration, unauthorized use of a motor vehicle, with dates of arrest of January 5th, as well as December 11th, 2022. But he has been in custody on these warrants since March 4th of 2023.
Yes.
And so as such, with the case is not being indicted or filed, we request under 17-151 relief.
Okay, any response from the state?
Your Honor, I would simply say, say to the court that we have not received a case from law enforcement at this time, so we're unable to do anything.
Ms. Gray, does the state have any type of criminal history of the defendant that the court would need to be aware of before granting a personal bond?
1 second, Your Honor. Well, I really don't. Judge, he has a misdemeanor pending here for theft, 750 to 2,500. He has a prior assault, bodily injury, and a prior possession of marijuana.
Judge, those that prior assault, I believe, was rejected in 2021. I don't believe there's a final conviction or disposition on that case.
I show it was 80 days time served with $5,400 in restitution.
And I apologize. That was for a different arrest.
And what are these offenses in this writ that he's accused of?
One is assault impeding, Your Honor.
Is it driving while license invalid, display fictitious registration, UUMV, and assault, family, impeding breath or circulation?
That's correct.
Yes, sir.
All right, court's gonna take that under advisement and I'll issue a ruling at the end of the docket.
Thank you. Thank you, Judge.
All right, Mr. Manning. Anyone else?
Judge, ready on arraignment for Mr. Walcott?
Okay, Mr. Walcott.
I'm sorry, I misspoke. I believe Mr. Walcott's here on a motion to revoke, Judge.
Mr. Walcott, I'm showing the arraignment, but you could be right. We looked it up to CR 21 case.
I show it's an MTR on a state jail drug case.
Yeah, it looks like he pled out in almost exactly 1 year ago. Okay, all right, so this is a motion to revoke hearing. All right, go ahead, Mr. Manning.
Judge, we'd like to be reset for the June 29th docket.
The June evidentiary docket, you said?
Yes, Judge, June 29th.
All right. All right, court will set Mr. Walcott then for the contested docket on June 29th at 1:30.
Judge, I believe that wraps everything up. My hearing with Mr. Wellborn is going to be a minute, so if Mr. White is ready, I'm fine taking a step back.
Okay.
Mr. White is ready.
All right, Mr. White, Mr. Balboa. This is cause numbers CR 22-124, CR 22-369. State Virgin Richard, Jason Balboa. Mr. Balboa, if you'll raise your right hand, I'm going to place you under oath. If you're ready, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right, thank you, lawyer. All right, so before we begin, Mr. White, can you give me the terms of the plea?
Your Honor, in exchange for Mr. Balboa's plea of guilty, the state's going to offer 4 years deferred adjudication, $1,000 fine, and as part of the agreement, Mr. Balboa is going to have to submit to safety. Oh, and they're going to 1245 the bell jumping case.
Okay, so 4 deferred, safe P at the condition.
Yes,
$1,000 fine, $290 court costs. Any restitution or reimbursements?
There's a 585 reimbursement, no restitution.
585 reimbursement?
Yes, sir.
I don't know what that would be for. You're usually 585 is when we have court appointed counsel. Do you know how that breaks down?
Your Honor, he had a court appointed counsel prior.
Okay, all right, there we go. 290 court costs, 585 reimbursement. You said no restitution, correct?
No restitution, Your Honor.
All right, Mr. Balboa, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with any type of mental condition?
No, Your Honor.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and his representation?
Yes, Your Honor.
Like you've had enough time to talk to him about your cases and that you've had all of your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, Your Honor.
Mr. White, you believe Mr. Balboa to be competent today?
Your Honor, I believe Mr. Balboa is competent and he understands the proceedings that are pending against him. For the court, there will be some waivers. He's executed those waivers knowingly, intelligently, and voluntarily. In addition, Your Honor, if I explained to him what happens on the deferred adjudication, the advantages and disadvantages of such a plea agreement, most notably if he violates any term or condition, there'll be a hearing. And if the court finds that he did in fact violate it, the court can sentence him anywhere in the punishment range, which is a minimum of 2 to a maximum of 10 in the TDC and up to a $10,000 fine.
Thank you, Mr. White. All right, Mr. Balboa, kind of repeating some of the things that Mr. White said, you understand that the range of punishment for this crime, if you were to be convicted and sentenced, could be anywhere from the minimum 2 years up to the maximum 10 years in prison. You understand that?
Yes, Your Honor.
And the fine could be anywhere to the maximum of $10,000. You understand that as well?
Yes, Your Honor.
As Mr. White said, if during the period of your community supervision, you you violate any of the terms and conditions, the state can file a motion to adjudicate your guilt. That means to convict you. And they could ask the court to do a number of things to you, including and up to revoking your community supervision, convicting you, and punishment being assessed at the maximum 10 years in prison. Do you understand that?
Yes, Your Honor.
And you understand that at that hearing, if that should happen, the issue of whether you evaded arrest or detention would not be the issue before the court. The issue would be whether you violated your conditions of community supervision. You understand that?
I do understand.
All right, understanding all those things, you still wish to go forward. Is that correct?
Yes, I do, Your Honor.
All right, then Mr. Balboa, how do you plead to evading arrest or detention with a vehicle, a third-degree felony?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty?
I'm sorry, can you repeat that?
Has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
Or it does accept the defendant's plea of guilt at this time. Mr. White, any objection to the state's evidence?
No objection.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, can the state give me the evidence to support the plea for the evading?
Yes, Your Honor. On the date alleged in the indictment, Canton police officers Jake Smith and Preston Roberts received information that a stolen vehicle was traveling through the county on the interstate. They made attempts to stop that vehicle. The vehicle was driven, in fact, by this defendant, but when they attempted to stop the vehicle, it fled from them at high rates of speed.
Thank you, Ms. Curry. Any objections to that summary, Mr. White?
No, sir.
All right, then based on the evidence presented in this case, the court finds that there is enough evidence to convict Richard Jason Balboa, or it follows the plea agreement. In this case, the court defers a finding of guilt on the charge of evading arrest or detention with a vehicle, places Mr. Balboa on 4 years community supervision, orders him to pay a $1,000 fine. Court also orders him to pay court costs of $290, reimbursement fees of $585. And the court will dismiss under section 1245, cause number CR 22-00369, bail jumping or failure to appear. And as a special condition of community supervision, the court will order Mr. Balboa to attend the substance abuse felony punishment facility known as Safety. Mr. Balboa, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Please step over with the deputy to be fingerprinted.
Yes, sir.
Mr. Abraham, is that everyone that's on the jail docket?
Except for Mr. Wellborn that
Oh,
Mr.
well,
Randy is speaking with.
Okay, good. All right, we'll stand by.
Okay. Sorry.
It's okay. All right, this is cause number CR 23-32 and -33. State versus Cody Lee Wellborn for pretrial in both cases. Also believe there's a motion for bond reduction. Let's take up the pretrial issues first.
Judge, at this time, we have no contested pretrial issues. We request to be set on a docket call.
All right, court sets Mr. Wellborn on docket call for each case, August 10th. At 1:30 if he's in jail, 9 AM if he's on bail. Are you gonna call your client on the motion?
Judge, we reached an agreement.
Okay, what's the agreement?
Judge, we're gonna reduce the CR 23-00032. It's currently at 150,000, be reduced to 75,000. CR 23-00033 be reduced from 50,000 to 25,000. And a condition of those is that he have no contact with the victim and that he have a GPS monitoring device on him installed before he leaves jail. Additionally, Judge, the possession of marijuana, which was 17-151, that one is agreed to by the state as well, as a case they have not filed yet at this time. And it's my understanding that as we were discussing the case, that Mr. Wellborn is currently represented by Mr. Doug Lowe on the assault that has no bond currently set on it. My understanding was that Mr. Wellborn was on bond, and when he got arrested on these offenses, that his bondsman went off the bond. And we're just asking for that bond to be reinstated. So if he's able to make bond, he can do so.
You said that the original charge was a misdemeanor case. Was that in Judge Winter's court?
Yes, Judge, and I believe it has been filed.
That's where Mr. Lowe is still representing.
That's correct. And I was unaware of that until today. My thought was that it was unfiled, but I believe it is filed, and he's being represented by Mr. Lowe.
So what was your request? Are you asking me to do something on the misdemeanor case that's in Judge Winter's court?
Judge, it just shows a no bond, and I'm not sure. We just asked that a bond be set in that case. I was unaware that it was filed in Judge Winter's court, so if necessary, I can file a motion in Judge Winter's court to have that heard.
Yeah, I think that would be best.
Yes, Judge.
Their jurisdiction over that. So, okay, all right. Then the court will approve the agreements on bail, and the court will sign that whenever it's provided by the parties to the court.
Judge, I've already filed an order that will need, I guess, the court to interlineate the amount that was agreed to, as well as the condition for no contact and GPS. But that was e-filed as a part of my writ.
Okay, I will see if I can find it.
And Judge, additionally, Mr. Davis and Miss O'Pry, I just needed to advise them as to what will have to be happening with their bond situations.
Okay, on Mr. Davis, court finding that he's been incarcerated over 90 days without indictment. Court's going to grant the personal bonds. They say PR bonds, but I'm gonna say personal bonds in the same amounts as listed. 150,000 on the evading arrest. Well, it's gonna be confusing. I'm just gonna send over an order that says all of these things on here.
Okay.
Now, and then I'm going to tell you that Mr. Manning, I'm also going to find that his $25,000 bond on his indicted case is insufficient, and I'm going to raise that.
Okay, and what was the basis for the insufficiency?
1, 2, 3, 4, 5 new allegations.
Okay.
All felonies. And then Ms. Opry, court's going to deny her request at this time. Should she get more medical information available to you as to specific medications and doctor's appointments, things of that nature, the court will reconsider that. I didn't consider her testimony to be credible today.
Yes, Judge. Judge, I believe that concludes my business. Might be excused.
Yes, thank you, Mr. Meehan.
Your Honor, did Stella give you that message about Mr. Zimmerman, that he is in TDC?
Yes, yeah, she did, and I've got the thing here, so we'll need to, when we get back, we'll just need to do an order withdrawing that NISA.
Okay, I mean, I don't think you didn't fill one out, right?
Zimmerman?
Okay,
So what we can do is, let's go back on our docket here. We don't have an attorney on Zimmerman yet anyway. So I guess what we'll need to do is allow the state an opportunity to review the case and let us know if they want to bench warrant or not, if they want to continue prosecution on the case. If so, then we can bench warrant and set it, we can set a date. Once we get him here, we can set a date.
okay. TDC said they just received him in May, so he's only been there just a few weeks.
Yeah, so Mr. Hartwell on this morning's docket, Michael Cody Zimmerman was set for arraignment on a second-degree demolition case, and it looks like he was received in TDC.
On a Dallas County charge. I believe it was manufactured.
You know, the printout here on the offender search doesn't show any new cases. The only Dallas County case that I'm seeing is the 2016 case
Right.
for 2 years.
She said they just got him in May.
I'm just not seeing that on this.
Right.
So, let's just go ahead and set Mr. Zimmerman for arraignment on August 8th. And we'll put status on bench warrant. So Mr. Hartwell, if y'all will review your case, make sure that you still want to prosecute that case in light of anything you've learned about him being in TDC. And then,
Yes, Your Honor.
and then if you want to continue that, just let us know. We'll bench warrant, get him down here and start the process.
Sounds good. Thank you, Your Honor.
All right, you're welcome, sir. All right, Ms. Taylor, does that conclude our docket today?
Yes, we'll be on our way back.
All right, on the way.
So we'll get this.
Robbie doesn't know what he's talking about. You better not let him near the.
I know, he's
Here, I'm just gonna kill it off.